Professional Issues in Information System, Module 5, Intellectual Property. Learning Objectives. What does the term intellectual property encompass? And why are organizations so concerned about protecting intellectual property? What are the strengths and limitations of using copyrights, patents, and trade secret laws to protect intellectual property? What is plagiarism, and what can be done to combat it? What is reverse engineering, and what issues are associated with applying it to create a lookalike of a competitor's software program? What is open source code, and what is the fundamental premise behind its use? What is the essential difference between competitive intelligence and industrial espionage? And how is competitive intelligence gathered? What is cyber squatting? And what strategy should be used to protect an organization from it? Intellectual property. Intellectual property is a term used to describe works of the mind, such as art, books, films, formulas, inventions, music, and processes that are distinct and owned or created by a single person or group. Intellectual property is protected through copyright, patent, and trade secret laws. Copyright law protects authorized works such as art, books, film, and music. Patent law protects inventions, and trade secret law helps safeguard information that is critical to an organization's success. Together, copyright and patent and trade secret legislation form a complex body of law that addresses the ownership of intellectual property. Such laws can also present potential ethical problems for IT companies and users. For example, some innovators believe that copyrights, patents, and trade secrets stifle creativity by making it harder to build on the ideas of others. Meanwhile, the owners of intellectual property want to control and receive compensation for the use of their intellectual property. Defining and controlling the appropriate level of access to intellectual property are complex tasks. For example, protecting computer software has proven to be difficult because it has not been well categorized under the law. Software has sometimes been treated as the expression of an idea, which can be protected under copyright law. In other cases, software has been treated as a process for changing a computer's internal structure, making it eligible for protection under patent law. At one time, software was even judged to be a series of mental steps, making it inappropriate for ownership and ineligible for any form of protection. Copyright. A copyright is the exclusive right to distribute, display, perform, or reproduce an original work in copies or to prepare derivative works based on the work. Copyright protection is granted to the creators of original works of authorship in any tangible medium of expression. It is now known or later developed from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. The author may grant this exclusive right to others. As new forms of expression develop, they can be awarded copyright protection. Copyright infringement is a violation of the rights secured by the owner of a copyright. Infringement occurs when someone copies a substantial and material part of another's copyrighted work without permission. Copyright law guarantees developers the rights to their works for a certain amount of time. Since 1960, the term of copyright has been extended 11 times from its original limit of 28 years. The Copyright Term Extension Act, also known as the Sonny Bono Copyright Term Extension Act, signed into law in 1998, established the following time limits. For works created after January 1, 1978, copyright protection endures for the life of the author plus 70 years. For works created but not published or registered before January 1, 1978, the term endures for the life of the author plus 70 years, but in no case expires earlier than December 31, 2004. For works created before 1978 that are still in their original or renewable term of copyright, the total term was extended to 95 years from the date the copyright was originally secured. These extensions were primarily championed by movie studios concerned about retaining rights to their early films. Opponents argued that the lengthening of the copyright period made it more difficult for artists to build on the work of others, thus stifling creativity and innovation. The Sonny Bono Copyright Term Extension Act was legally challenged by Eric Eldred, a bibliophile who wanted to put digitized editions of old books online. The Eldred-Ashcroft case went all the way to the Supreme Court, which ruled the act of constitutional in 2003. Eligible works, the types of work that can be copyrighted, include architecture, art, audiovisual works, choreography, drama, graphics, literature, motion pictures, motion pantomimes, pictures, sculptures, sound recordings, and other intellectual works as described in Title 17 of the U.S. Code. To be eligible for a copyright, and a work must fall within one of the preceding categories, and it must be original. Copyright law has proven to be extremely flexible in covering new technologies. Thus, software, video games, multimedia works, and web pages can all be protected. However, evaluating the originality of a work is not always a straightforward process, and disagreements over whether or not a work is original sometimes lead to litigation. Some works are not eligible for copyright protection, including those that have not been fixed in a tangible form of expression, such as an improvisational speech, and those that consist entirely of common information that contains no original authorship, such as a chart showing conversions between European and American units of measure. Fair use doctrine. Copyright law tries to strike a balance between protecting an author's rights and enabling public access to copyrighted works. The fair use doctrine was developed over the years as courts worked to maintain that balance. The fair use doctrine allows portions of copyrighted materials to be used without permission under certain circumstances. Title 17, Section 107 of the U.S. Code established that courts should consider the following 4 factors when deciding whether a particular use of copyrighted property is fair and can be allowed without penalty. Number 1. The purpose and character of the use, such as commercial use or non-profit, educational purposes. Number 2. The nature of the copyrighted work. Number 3. The person of the copyrighted work used in relation to the work as a whole. And number 4. The effect of the use on the value of the copyrighted work. Software copyright protection. The use of copyrights to protect computer software raises many complicated issues of interpretation. For example, a software manufacturer can observe the operation of a competitor's copyrighted program and then create a program that accomplishes the same result and performs in the same manner. To prove infringement, the copyright holder must show a striking resemblance between its software and the new software that could be explained only by copying. However, if the new software's manufacturer can establish that it developed the program on its own without any knowledge of the existing program, there is no infringement. For example, two software manufacturers could conceivably develop a separate but nearly identical programs for a simple game, such as tic-tac-toe, without infringing the other's copyright. Measures for protections of intellectual property. The Prioritizing Resources and Organization for Intellectual Property, or PROIP Act of 2008, increased trademark and copyright enforcement and substantially increased penalties for infringement. For example, the penalty for infringement of a 10-song album was raised from $7,500 to $1.5 million. The law also created the Office of the United States Intellectual Property Enforcement Representative within the U.S. Department of Justice. One of its programs, called CHIP, or Computer Hacking and Intellectual Property, is a network of over 150 experienced and specially trained federal prosecutors who focus on computer and intellectual property crimes. General Agreement on Tariffs and Trade, or GATT. The General Agreement on Tariffs and Trade was a multilateral agreement governing international trade. There were several rounds of negotiations addressing various trade issues. GATT includes a section covering copyrights called the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. Despite GATT, however, copyright protection varies greatly from country to country, and an expert should be consulted when considering the international usage of any intellectual property. The WTO and the WTO TRIPS Agreement 1994, the World Trade Organizations, or WTO, is a global organization that deals with rules of international trade based on WTO agreements that are negotiated and signed by representatives of the world's trading nations. The WTO is headquartered in Geneva, Switzerland, and had 158 member nations as of February 2013. The goal of the WTO is to help producers of goods and services, exporters and importers conduct their business. Many nations recognize that intellectual property has become increasingly important in world trade. Yet, the extent of protection and enforcement of intellectual property rights varies around the world. As a result, the WTO developed the Agreement on Trade-Related Aspects of Intellectual Property Rights, also known as the TRIPS Agreement, to establish minimum levels of protection that each government must provide to the intellectual property of all WTO members. This binding agreement requires member governments to ensure that intellectual property rights can be enforced under their laws and that penalties for infringement are tough enough to deter further violations. The World Intellectual Property Organization, or WIPO, headquartered in Geneva, Switzerland, is an agency of the United Nations established in 1967. WIPO is dedicated to the use of intellectual property as a means to stimulate innovation and creativity. It has 185 member nations and administers 25 international treaties. Since the 1990s, WIPO has strongly advocated for the interest of intellectual property owners. Its goal is to ensure that intellectual property laws are uniformly administered. The WIPO Copyright Treaty, adopted in 1996, provides additional copyright protection to address electronic media. The treaty ensures that computer programs are protected as literary works and that the arrangement and selection of material in databases is also protected. It provides authors with control over the rental and distribution of their work and prohibits circumvention of any technical measures put in place to protect the works. The WIPO Copyright Treaty is implemented in U.S. law through the Digital Millennium Copyright Act or DMCA. The Digital Millennium Copyright Act of 1998 was signed into law in 1998 and implements two 1996 WIPO treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. The Act is divided into the following 5 sections. Title 1, WIPO Copyright and Performances and Phonograms Treaties and Implementation Act of 1998. This section implements the WIPO treaties by making certain technical amendments to U.S. law in order to provide appropriate references and links to the treaties. It also creates 2 new prohibitions in the Copyright Act, Title 17 of the U.S. Code, one on circumvention of technological measures used by copyright owners to protect their works, and one on tampering with copyright management information. Title 1 also adds civil remedies and the criminal penalties for violating and prohibitions. Title 2, Online Copyright Infringement Liability Limitation Act. This section enables website operators that allow users to post content on their website, that is in terms of music, video, and pictures. This is to avoid copyright infringement liability if certain safe harbor provisions are followed. Title 3, Computer Maintenance Competition Assurance Act. This section permits the owner or lessee of a computer to make or authorize the making of a copy of a computer program in the course of maintaining or repairing that computer. The new copy cannot be used in any other manner and must be destroyed immediately after the maintenance or repair is completed. Title 4, Miscellaneous Provisions. This section adds language to the Copyright Act confirming the Copyright Office's authority to continue to perform the policy and international functions that it has carried out for decades under its existing general authority. And Title 5, Vessel Hull Design Protection Act. This section creates a new form of protection for the original design of vessel hulls. So this is the summary of the WTO TRIPS agreement. Let's talk about patents. A patent is a grant of a property right issued by the United States Patent and Trademark Office, or the USPTO, to an inventor. A patent permits its owner to exclude the public from making, using, or selling a protected invention, and it allows for legal action against violators. Unlike a copyright, a patent prevents independent creation as well as copying. Even if someone else invents the same item independently and with no prior knowledge of the patent holder's invention, the second inventor is excluded from using the patented device without permission of the original patent holder. The rights of the patent are valid only in the United States and its territories and possessions. To obtain a U.S. patent, an application must be filed within the USPTO according to strict requirements. As part of the application, the USPTO searches the prior art, meaning the existing body of knowledge available to a person of ordinary skill in the art, starting with patents and published material that have already been issued in the same area. The USPTO will not issue a patent for an invention whose professed improvements are already present in the prior art. A software patent claims as its invention some feature or process embodied in the instructions executed by a computer. The courts and the USPTO have changed their attitudes and opinions on the patenting of software over the years. Prior to 1981, the courts regularly turned down requests for such patents, giving the impression that software could not be patented. Patent infringement, or the violation of the rights secured by the owner of a patent, occurs when someone makes unauthorized use of another's patent. Unlike copyright infringement, there is no specified limit to the monetary penalty if patent infringement is found. The U.S. Supreme Court has ruled that three classes of items cannot be patented: abstract ideas, laws of nature, and natural phenomena. Standing on its own, mathematical subject matter is also not entitled to patent protection. The statute does not identify computer software, gene sequences, or genetically modified bacteria as patentable subject matter. However, these items have subsequently been determined to be patentable. Figure 6-2 shows the number of patents applied for and granted in recent years. The Leahy-Smith America Invents Act represents a major change in U.S. patent law. Under this law, which was passed in 2011, the U.S. patent system changed from a first to invent to a first inventor to file system effective March 16, 2013. That means, if two people file for a patent application on the same invention at approximately the same time, the first person to file with the USPTO will receive the patent, not necessarily the person who actually invented the item first. The America Invents Act also expanded the definition of prior art used to determine the novelty of an invention and whether it can be patented. For example, if something resembling your invention were on sale anywhere in the world before you filed for a patent, that item is now considered part of the prior art and could prevent you from obtaining a patent. Cross-licensing agreements. Many large software companies have cross-licensing agreements in which each party agrees not to sue the other over patent infringements. For example, Apple and HTC battled for several years over various mobile phone-related patents, which eventually led to the U.S. International Trade Committee banning imports of two models of the HTC mobile phone. The two companies eventually agreed to a 10-year cross-licensing agreement that permits each party to license the other's current and future patents. Major IT firms usually have little interest in cross-licensing with smaller firms. As a result, small businesses must pay an additional cost from which many larger companies are exempt. Furthermore, small businesses are generally unsuccessful in enforcing their patents against larger companies. Should a small business bring a patent infringement suit against a large firm, the larger firm can overwhelm the small business with multiple patent suits, whether they have merit or not. Considering that the average patent lawsuit costs $3 to $10 million and takes 2 to 3 years to litigate, a small firm often simply cannot afford to fight. Instead, it usually settles and licenses its patents to the large company. Trade secrets. Trade secret protection begins by identifying all the information that must be protected, from undisclosed patent applications to market research and business plans, and developing a comprehensive strategy for keeping the information secure. Trade secret law protects only against the misappropriation of trade secrets. If competitors come up with the same idea on their own, it is not misappropriation. In other words, The law doesn't prevent someone from using the same idea if it was developed independently. Advantages of trade secret laws. Trade secret laws protect more technology worldwide than patent laws do, in large part because of the following key advantages. There are no time limitations on the protection of trade secrets, as there are with patents and copyrights. There is no need to file an application, make disclosures to any person or agency, or disclose a trade secret to outsiders to gain protection. That is, after the USPTO issues a patent, competitors can obtain a detailed descriptions of it. Therefore, no filing or application fees are required to protect a trade secret. Although patents can be ruled invalid by the courts, meaning that the affected inventions no longer have patent protection, this risk does not exist for trade secrets. Uniform Trade Secrets Act, or UTSA, was drafted in the 1970s to bring uniformity to all the United States in the area of trade secret law. The UTSA define a trade secret as information including a formula, pattern, compilation, program, device, method, technique, or process that, number 1, derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by persons who can obtain economic value from its disclosure or use. And number 2 is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Under these terms, computer hardware and software can qualify for trade secret protection by the UTSA. The Economic Espionage Act, which is EEA of 1996, imposes penalties of up to $10 million and 15 years in prison for the theft of trade secrets. Employees are the greatest threat to the loss of the company trade secrets. They might accidentally disclose trade secrets or steal them for monetary gain. Organization must educate employees about the importance of maintaining the secrecy of corporate information. Trade secret information should be labeled clearly as confidential and should only be accessible by a limited number of people. Most organizations have strict policies regarding non-disclosure of corporate information. Because organization can risk losing trade secrets when key employees leave, they often try to prohibit employees from revealing secrets by adding non-disclosure clauses to employment contracts. Thus, departing employees cannot take copies of computer programs or reveal the details of software owned by the firm. Employers can also use non-compete agreement to protect intellectual property from being used by competitors when key employees leave. A non-compete agreement prohibits an employee from working for any competitors for a period of time, often 1 to 2 years. Plagiarism and Actions to combat student plagiarism. Plagiarism is the act of stealing someone's ideas or words and passing them off as one's own. The explosion of electronic content and the growth of the web have made it easy to cut and paste paragraphs into term papers and other documents without proper citation or quotation marks. The following list shows some of the actions that schools can take to combat student plagiarism. Number 1. Help students understand what constitutes plagiarism and why they need to cite sources properly. 2. Show students how to document web pages and materials from online databases. 3. Schedule major writing assignments so that portions are due over the course of the term, thus reducing the likelihood that students will get into a time crunch and be tempted to plagiarize to meet the deadline. 4. Make clear to students that instructors are aware of internet paper mills. 5. Ensure that instructors both educate students and about plagiarism detection services and make students aware that they know how to use these services. And number 6, incorporate detection software and services into a comprehensive anti-plagiarism program. Table 6-3 shows the partial list of plagiarism detection services and software. These software products can be used as a tool to combat plagiarism. Reverse engineering. Reverse engineering is the process of taking something apart in order to understand it, build a copy of it, or improve it. Reverse engineering was originally applied to computer hardware but is now commonly applied to software as well. Reverse engineering of software involves analyzing it to create a new representation of the system in a different form or at a higher level of abstraction. Often, reverse engineering begins by extracting design stage details from program code. Design stage details about an information system are more conceptual and less defined than the program code of the same system. Software license agreements increasingly forbid reverse engineering. As a result of the increased legislation affecting reverse engineering, some software developers are moving their reverse engineering projects offshore to avoid US rules. Open source code. Open source code is any program whose source code is made available for use or modification as users or other developers see fit. The basic premise behind open source code is that when many programmers can read, redistribute, and modify a program's code, the software improves. Programs with open source code can be adapted to meet new needs and bugs can be rapidly identified and fixed. Open source code advocates believe that this process produces better software than the traditional closed model. Why would firms or individual developers create open source code if they do not receive money for it? Here are the several reasons. Number 1, some people share code to earn respect for solving a common problem in an elegant way. 2, some people have used open source code that was developed by others and feel the need to pay back by helping other developers. 3, a firm may be required to develop software as part of an agreement to address a client's problem. If the firm is paid for the employee's time spent to develop the software rather than for the software itself, it may decide to license the code as open source and use it either to promote the firm's expertise or as an incentive to attract other potential clients with a similar problem. 4, a firm may develop open source code in the hope of earning software maintenance fees if the end user's needs change in the future. And 5, a firm may develop useful code but may be reluctant to license and market it, and so might donate the code for the general public. Table 6-4 shows some examples of commonly used open source software. Competitive intelligence. Competitive intelligence is a legally obtained information that is gathered to help a company gain an advantage over its rivals. Competitive intelligence is often integrated into a company's strategic plan and executive decision-making. Competitive intelligence is not the same as industrial espionage, which is the use of illegal means to obtain business information not available to the general public. A wide array of software application, databases, and social media tools are available for companies and are individuals looking for competitive intelligence data, including the following. Rapportive is software that can be added to your email application or web browser to to provide you with rich contact profiles that show you what people look like, where they are based, and what they do. Such information can help you build rapport quickly by enabling you to mention and shared interests. 2. Crunchbase is a free database of technology of over 110,000 companies, people, and investors. 3. CORI, or the CORI, is a database of contract documents available online using a full-text search and retrieval system. 4. Thamasnet.com is an excellent source for identifying suppliers and sources for products. And number 5, WhoGotFunded.com is a comprehensive website of data about what organizations have received funding and for what purposes. Trademark infringement. A trademark is a logo, package, design, phrase, sound, or word that enables a consumer to differentiate one company's products from another's. Consumers often cannot examine goods or services to determine their quality or source, so instead, they rely on the labels attached to the products. The Lanham Act of 1946, also known as the Trademark Act, Title 15, Chapter 22 of the U.S. Code, defines that the use of a trademark, the process for obtaining a trademark from the Patent and Trademark Office, and the penalties associated with trademark infringement. The law gives the trademark's owner the right to prevent others from using the same mark or a confusingly similar mark on a product's label. Nominative fair use is a defense often employed by the defendant in trademark infringement cases where a defendant uses a plaintiff's mark to identify the plaintiff's products or services in conjunction with its own product or services. To successfully employ this defense, the defendant must show 3 things. 1. The plaintiff's product or service cannot be readily identifiable without using the plaintiff's mark. 2. It uses only as much of the plaintiff's mark as necessary to identify the defendant's product or service. And 3. The defendant does nothing with the plaintiff's mark that suggests endorsement or sponsorship by the plaintiff. Cybersquatting. So these are companies that want to establish an online presence, know that the best way to capitalize on the strengths of their brand names and trademarks is to make the names part of the domain names for their website. When websites were first established, there was no procedure for validating the legitimacy of requests for website names, which were given out on a first-come, first-served basis. And in the early days of the web, many cybersquatters registered domain names for famous trademarks or company names to which they had no connection, with the hope that the trademark's owner would eventually buy the domain name for a large sum of money. The main tactic organizations use to circumvent cybersquatting is to protect a trademark by registering numerous domain names and various as soon as the organization knows it wants to develop a web presence. In addition, trademark owners who rely on non-English speaking customers often register their names in multilingual form. Registering additional domain names is far less expensive than attempting to force cybersquatters to change or abandon their domain names. Internet Corporation for Assigned Names and Numbers, or ICANN. Other tactics can also help curb cybersquatting. For example, the Internet Corporation for Assigned Names and Numbers, or ICANN, is a non-profit corporation responsible for managing the Internet's domain name system. Prior to 2000, 8 generic top-level domain names were in existence: .com, .edu, .gov, .int, .mil, .net, .org, and .arpa. In 2000, ICANN introduced 7 more: .aero, .biz, .coop, .info, .museum, .name, and .pro. In 2004, ICANN introduced .asia, .cat, .mobi, .tel, and .travel. The generic top-level domain .xxx was approved in 2011. With each new round of generic top-level domains, current trademark holders are given time to assert rights to their trademarks in the new top-level domains before registrations are opened up to the general public. ICANN also has a uniform domain name dispute resolution policy, under which most types of trademark-based domain name disputes must be resolved by agreement, court action, or arbitration before a registrar will cancel, suspend, or transfer a domain name. The ICANN policy is designed to provide for the fast, relatively inexpensive arbitration of a trademark owner's complaint that a domain name was registered or used in a bad faith. The Anti-Cyber Squatting Consumer Protection Act, or ACPA, enacted in 1999, allows trademark owners to challenge foreign cyber squatters who might otherwise be beyond the jurisdiction of U.S. courts.